Hey, regarding your last slide and sort of, I guess, permeated your entire discussion, certainly in regards to the amount of information we're talking about, what really keeps all sides honest in regards to divulging everything? Is it that easy to bust people if they don't?
Sure. Yeah, I mean, there's, honestly, I think it's a combination of let's come at it from a few different points. One is everybody isn't always honest, which is unfortunate but true. Two is you do have the federal rules that are in place, and you do have lawyers both in-house and at their outside firms that would be effectively disbarred if they knowingly got into a situation in which they were causing material to be destroyed or violating their obligations as it relates to discovery. And then three, you have there are any number of cases in which not only the party that was producing the data, but also their counsel have been sanctioned. So there are, national firms like, for example, Kirkland & Ellis was personally sanctioned. They paid money in the Morgan Stanley litigation. And the lawyers from Kirkland & Ellis who were admitted pro hoc vice in the Florida court to actually appear there had their admissions pro hoc vice rescinded by the court, and they could no longer represent Morgan Stanley in that litigation. So you have some really, really serious repercussions waiting for you to, if you don't actually adhere to your obligations under this. And so as a result of, I mean, that's basically the only safeguard that you can put in place.
Has the marketplace responded to, and this might be a general question, but has the marketplace responded to certain needs of e-discovery? Like, are there certain products that, have lawyers approached IBM and say, hey, can you modify Lotus Notes so that, we can?
Absolutely. I mean, you guys will get the flavor of this. When Lexis owns the largest electronic discovery vendor now you're talking about big money, because the Lexis guys went out and they saw the fact that this was absolutely consuming upwards of a third of the litigation budgets that people were laying out in the tens of millions of dollars to get involved in big time litigation. So they have larger companies have absolutely come into the space, and they've created tailored software applications that are built specifically for working with electronic discovery. I'm thinking of, I use a system called FYI Concordance. Concordance is, you can pull a metadata document up and you can actually marry it together with a TIFF image of the same document, so you can look at it in two different formats simultaneously.
This might be getting a little bit beyond the litigation aspect of things, but have you seen any evidence that these kinds of pressures from metadata and things like that are almost pushing IT vendors to change the document formats that they use? I mean, there's big issues right now in the computer industry with Microsoft and its open document formats that could aid to things like this, like being able to attach metadata automatically.
Sure. I haven't seen so much in folks actually taking it further to the vendors to actually rewrite their program applications, but I will tell you that there's so much at stake and there's so much money involved in the marketplace right now as it relates to it. I guarantee you that there are specific applications that Microsoft would be building, or revisions or alterations to the systems that they have in place that Microsoft would be executing.
Yeah, how organized do productions have to be, these kind of electronic productions? With respect to, you have, let's say, transaction sheets from a certain year,
sure,
and certain transaction sheets from another year, and emails regarding pursuant to both those transactions, or all together. Do they have to be separated? Can they just be thrown into like a?
It's a great question, because back in the day, in paper production under Rule 34, you couldn't get away. People would try it all the time. They just send over 800 boxes worth of stuff and say, somewhere in here you'll find the documents that are responsive to the 65 document requests that you serve. and courts wouldn't stand for that, and they'd say you have to actually parse out and be able to identify the documents responsive to document request number 17 are in range 1 through 1,000, and the documents responsive to request number 18 are from 1,001 to 5,000. And you could actually set it out that way. Or, as you know from the federal rules, you could also just produce it in the ordinary course, how they're maintained, how the files actually physically sit in the file cabinet. But all that goes out the window now, because now you're talking about ESI. So you're cobbling this stuff together from so many different sources, and you're going to actually assemble it yourselves, meaning you, the firm producing the information. So to answer your question, what you ultimately wind up doing is you usually work that out with your adversary. You say, look, this is the universe of what I have and what I'm collecting. This is what you're looking for. How do you want me to produce it to you? I mean, people still try to this day to just basically give you a data dump, to just really just send over a terabyte worth of crap and say, have at it, boss, and you can just start without page breaks in it and just start to figure it out, and then you wind up in front of a magistrate judge, and that doesn't fly. So the answer is it's a case-by-case basis. There is no one universal application. Well, again, thanks to one and all, and good luck.